And so I thought that the most recent development presented a good opportunity for me to add my voice to the conversation. So a little bit about me. I am a licensed attorney and I practice in the free state of Texas. And my videos are going to just provide a purely objective legal analysis of the issues. Okay, so it's going to be free from my opinion, free from any politics, and frankly, hopefully free from a lot of the bull that's been floating around our community in recent weeks. And so, guys, I am going to post links to all of the documents and all of the laws that we discussed today in the description below. And I really encourage you, go check those sources out for yourself, okay? So what happened? Yesterday, Military Arms Channel came into possession of a leaked document from the ATF. So this document is a draft document, okay, it's not finalized, and it's what's called a guidance document. Okay, it's a little bit different than almost all of the other ATF documents that have dealt with stabilizing braces. And that document was later posted onto the internet, and it's really been causing a stir in the 2A community today. But before we really dive into the document, I wanted to address something right off the bat. Okay, nothing in this leaked document suggests that the ATF will or is trying to ban stabilizing braces. In page 5, we can see that the ATF states, they're not in the business of regulating individual firearm components. However, individual firearm components can affect the overall classification of a firearm. But this is something that's entirely consistent with what the ATF has said in previous documents and letters that they've released, okay? And so when a stabilizing brace, this is according to the ATF, when a stabilizing brace is used in a way that's not consistent with the purpose of one-handed stabilization, then that might have an effect on the classification of that firearm. So what does the document say? Really, it only says 3 things. First, it outlines what the ATF is calling objective design features. And these are some of the things the ATF says it's going to consider when it's determining the classification of a firearm, okay? So it's what they're looking at when they're determining, okay, is this an AR-15 pistol or is this a short-barreled rifle? Second, it outlines the ATF's enforcement policy for everyone that is a current owner at the time of publication of the final document of an AR-15 pistol, or what the ATF is calling in this document a stabilizer-equipped firearm. Okay, so they're not calling them AR-15 pistols anymore, they're calling them stabilizer-equipped firearms. Third, the last thing that the document talks about is a preview of this expedited registration system and retroactive tax waiver program that the ATF is developing under the leadership of the Department of Justice. So first, okay, what are these objective design features? Now, these are things that you might have heard before. The document lays out a number of these different features. And these are things that the ATF is going to consider when they're determining the classification of a firearm. Okay, you've got things like the caliber, the weight, the overall length of pull. Are there sights on the firearm? Are there scopes on the firearm? Does it have any secondary grips like a pistol grip? So they also go into the characteristics of stabilizing braces themselves, okay? And this is something that we got a taste of when they came down on Q a couple weeks ago. They're also looking at, does it have any interchangeable parts with stocks that are on the market? And they list a few other things. But one note is that the ATF does make it a point to say that no single characteristic will necessarily affect the outcome of a classification determination, okay? So the ATF, and they've said this before, that when a weapon is submitted to approval, they take it on a case-by-case basis, and it's a holistic examination. And importantly, perhaps one of the most important things is that the ATF says this list is not exhaustive. That means that in the future, the ATF may consider other factors, and that's, as technology develops, as gun manufacturers become more clever, the ATF is reserving the right to say, okay, well, in the future, we're going to look at different things, maybe, but we haven't determined what those are, and so we can't tell you what they are right now. They're also going to look at the manufacturer's stated intent, the manufacturer's marketing efforts. So when Q got sued a couple weeks ago, the ATF pointed to one instance on Q's website where instead of saying pistol when they were describing the honey badger, it used the word rifle. Okay, so this is something to put manufacturers on notice. Hey, you have to be extremely careful with your marketing materials. But even more important than that is the ATF says that, look, we're going to look at what gun influencers and what people on YouTube, how they're using the product or the firearm. So even if a company says the intended purpose of this component is to, work as a stabilizing brace, and all of their marketing efforts, say the same thing, if a really popular gun YouTuber reviews the product and they keep shouldering it every time they're firing it, the ATF says that might be something that we take into consideration. Okay, additionally, the ATF says how the public at large uses a component is also something we're going to take into consideration. So, there might be like a wink and a nod between some companies and the public about this is a stabilizing brace, you can't shoulder this. And then the public says, okay, we got you, and then everyone shoulders. The ATF says, look, how the public uses your product, we are going to take that into consideration. So that's, it's an interesting development, and they're putting manufacturers on notice of these new factors. Okay, second big revelation from this document is the ATF outlines their enforcement policies for all current owners of AR-15 pistols, or what they're calling stabilizer-equipped firearms. And so they say that, they understand that most of the people that purchased all of these braces, they did so in good faith. And they did so precisely to comply with the law, right? Why would anyone buy a stabilizing brace if they didn't care about the law? Because then they would just put a stock on their sub 16-inch rifle barrel. And so in line with that understanding, they're saying the ATF and the DOJ are partnering to implement a separate expedited SBR and SBS registration process. And the Attorney General is going to separately plan to retroactively waive stabilizer-equipped firearms from the standard $200 tax stamp. But again, that's going to apply only to owners of stabilizer-equipped firearms prior to publication of the document. Regarding the registration and tax waiver program, details are really slim. Okay, remember, this is just a notice document. This is just a guidance document. And they say they're going to provide 4 options. The first is this expedited registration process. Second option, you can remove the stabilizing brace from your firearm and destroy it. Third option, you can swap the upper so that your barrel is 16 inches or longer for a rifle, or 18 inches or longer for a shotgun. Or you can surrender the firearm to the ATF. Until those options have been totally ironed out, the ATF says they are not going to enforce the registration provision on anyone who has sold, manufactured, transferred any stabilizer-equipped firearm before the publication of the final notice. Okay, so what does that mean? This means that until those 4 options are finalized, the ATF is not going to, change its enforcement policies for AR-15 pistols. So, unless something really changes, the ATF is not going to bust down your door and kill your dog because you got a stabilizing brace on your firearm. Okay, so now let's turn our attention to some of the potential issues and questions that people have had since this document got leaked. Okay, first, arbitrary and capricious. Some viewers might be asking, hey, the ATF has stated that they're considering all these factors holistically, and there might even be unnamed factors at play when they're making these determinations. So isn't that an impermissible way of regulating, pursuant to the Administrative Procedure Act? And, that's a really great question, but the answer is probably not. When a court is determining whether a federal agency was acting arbitrarily or capriciously, it's going to apply what's called Chevron deference. And that means the court is going to defer to whatever the agency did, as long as there's some rational, reasonable reason behind the agency act. And I think that the ATF, even if we may not personally agree with it, they have a strong case to say there is at least a rational basis behind these new ways of regulating, and they have a strong legal argument in that sense. So another thing some people have been upset by is this 14-day comment period. And 2 weeks really doesn't seem like enough time for the public to adequately respond to all this new information that we're going to have once they publish the final document. And some people are saying, hey, when a regulatory agency engages in a proposed rulemaking, like when they make a new rule, they're actually required to have up to a 90-day public comment period. And that would be the case here, but the ATF isn't making a new rule. This is what's called a guidance document, so this isn't a rulemaking. And in 2019, President Trump signed an executive order which allowed federal agencies like the ATF to cut through some regulatory red tape and to be able to govern and regulate more efficiently, more fast, more cheaply. One of the things that executive order did is allowed agencies to issue what are called guidance documents. And guidance documents are not subject to that 90-day public comment period. In fact, guidance documents aren't subject to any public comment, okay? So, theoretically, the ATF could just issue this and say, hey, here is, our new guidance document, and here's the new way that we're gonna do business, and you all have to adjust accordingly starting right now. The ATF said, look, we understand this is a really interesting topic for a lot of people in the 2A community. And so that's why they're giving out of an abundance, I don't know, however they want to describe it, they're not obligated, but they are offering the 14-day comment period. Another issue people have raised is, hey, does the ATF even have the authority to waive these the $200 tax stamp for their stabilizer equipped firearms? Because if you kind of follow that logic, yeah, that's an interesting question, because if they have the authority to waive it, might they also have the authority to increase the tax to whatever they want? But again, this answers no, because they actually don't have the authority. That's why they're partnering with the DOJ and specifically with the Attorney General, and it will be he or she that is going to implement this retroactive tax waiver program. And so yeah, the tax waiver does look like it's going to stick. The last issue that I want to talk about that I see raised a lot is this kind of disclaimer language at the end, right before the comment section. And the last few sentences pretty much say, okay, this document cannot be relied upon to create any rights. So if people can't, rely on this to guide their behavior going forward, what good is it? Is the document just a suggestion? Is this the ATF saying, hey, we hope you comply with this? Not quite. So the ATF is basically saying, okay, we're publishing this notice to let the public know our plans for the future, but we don't plan on changing our enforcement policies in the meantime. However, if we do, you can't hold up this guidance document in court and say, but you said you weren't going to enforce it in this letter. So the chances of that happening I would say, are really slim. But yeah, the ATF is just trying to cover their bases there. So there is a lot of information packed into this leaked draft of this document. And, there's still a lot of questions that many of us in the 2A community have. So question one, which lowers are going to qualify for this new tax waiver program? Is it only pistol or only AR-15 lowers that were sold as pistols, as complete pistol lowers or complete pistol firearms? Or is it any lower that has a stabilizing brace on the end of it? Because I know a lot of people that have built pistols themselves out of stripped lowers. Are they going to get the benefits of this tax waiver program? What about people with any other weapons or AOWs? How does this process affect those guns? Who knows? That's why it is so important for us to submit thoughtful, respectful comments during the public comment period, because there is a lot left unanswered by this document. So I really hope that this has helped clear up any questions that maybe you or some people around you have had about this draft guidance document. And you can be sure that once the ATF publishes the final document, maybe tomorrow, that I will upload an updated video that addresses any changes or any new information that we have. Also, the last few pages of the document deal with the comment procedure during the public comment period. And it's actually a little bit nitpicky. So I am also going to make a video which details how you can submit your comments, because you can do it in a number of ways. Fax or email or mail. And they're also very particular about what information will be shared publicly. So if you just write a letter, one-page letter, it looks like they are going to recreate the entire letter, and then that will be published in the Federal Register. So if you don't want your name or your address included in the comment that you submit, you need to follow some procedures, and I'm going to be making a video that goes over all of that. Y'all, please post your comments or any questions that you might have, and I'm going to try to get to all of them tonight or tomorrow, at least before the final document is published. And it looks like we're in for some pretty interesting weeks ahead, so stay tuned.